and welcome back to our channel. Today we are diving into the intriguing world of trademark opposition. Let's talk about an important aspect of trademark procedures: trademark objection and trademark opposition. These terms often confuse people, so let's clear things up and understand the key differences between the two. First, let us discuss trademark objection. A trademark examiner will issue a trademark objection during the registration process. No fees are required to be paid for this, and the applicant needs to respond within 1 month. If the applicant fails to respond, the trademark may be removed. In case of rejection, an appeal can be made. Now, let us move on to trademark opposition. This happens when a third party opposes a trademark application. Fees are required to be paid for filing an opposition, and the applicant has 3 months to respond, with a possible extension of 1 more month. If no response is received, the trademark may be removed. Just like with trademark objection, an appeal can be made after the judgment is passed. To file an opposition, the opponent needs to fill out Form TM5, which includes various details. For example, they need to mention the impugned application number and indicate the goods or services from the trademark application. They also need to provide the name of the applicant for the trademark sought to be opposed. In addition, the opposing party's details differ based upon their relationship to the trademark. If the opposition is filed by the trademark owner of an earlier mark, their name and address must be mentioned, along with an indication of their ownership. If a trademark licensee files the opposition, the licensee's name and address should be provided, along with the indication that they have been authorized to oppose. And if a successor files the opposition to the registered trademark owner, their name and address, along with the date of the application for the new proprietor, must be mentioned. If the opposing party is located outside India, their name, address, and address for service in India are required. To conclude, trademark objection is an internal process initiated by the trademark examiner, while trademark opposition comes from a third party. They differ in terms of fees, response time, and the potential removal of the trademark. Remember, both processes allow for an appeal after the respective outcomes. So now let's talk about trademark opposition. Once a trademark is published in the Trademarks Journal, there's a 4 month window for anyone to oppose its registration. You don't even need to have your own trademark in India to do so. Let's talk procedure. Once you decide to oppose, you've got to do it within those 4 months. The registrar will then send a copy of your opposition to the trademark applicant within 3 months, and they in turn have 2 months to file their counter statement defending their application. Here's a cool thing: the applicant can speed things up by filing the counter statement even before getting your notice of opposition. But if they miss the deadline or don't respond, then their trademark might get abandoned. Once the counter statements are in, we move to the evidence stage. Affidavits go back and forth between the parties, supporting their stance on the matter, and don't forget, both sides need to keep up, or the opposition might be dropped. Finally, after all the paperwork, it's showtime. The registrar will hold a hearing considering all the evidence presented and make a call on whether to approve the trademark or not. But wait, there's more. If you're not happy with the registrar's decision, you can challenge it. Yep, file a review with the registrar or an appeal before the Intellectual Property Appellate Board. What steps to take if your trademark has been opposed? Now, picture this. You've got your business all set up and you have even applied for trademark registration for your awesome brand name. Life seems to be going smoothly until one day, bam, you get a dreaded notice of trademark opposition. It's like someone just pulled the emergency brake on your business journey. Trademark opposition is when someone believes that your brand name violates certain rules or infringes on their existing trademark. It can turn into a real headache, causing damage to your business and brand reputation if not handled properly. Now, you might be wondering, how on earth can I save myself from this nightmare? Well, fear not. We've got some tips to help you navigate through these troubled waters. First and foremost, do not panic. Take a deep breath and carefully review the opposition notice. Understand the specific claims made against your brand name and do some research to verify the legitimacy of the opposition. Next, it's time to call in the professionals. Reach out to a trademark attorney who specializes in intellectual property law. They are the superheroes of the trademark world and can guide you through the entire process, representing your interests and fighting for your brand. In some cases, negotiation can be your saving grace. Try to communicate with the opposing party to find a middle ground or see if they are open to coexistence agreements. Sometimes a compromise can be reached that benefits both the parties. If negotiations don't work out, it might be necessary to prove your case before the trademark office or court. This is where having solid evidence and a strong defense strategy comes into play. Your attorney will help prepare a counter statement to the opposition addressing each ground raised in the notice. This is your opportunity to present arguments and evidence supporting the validity of your trademark. Gather evidence of your trademark's use, reputation, and distinctiveness in the marketplace. This evidence will support your case during the proceedings. In some cases, a hearing might be scheduled by the Trademark Registry or IPAB, that is, Intellectual Property Appellate Board. Your attorney will represent you during the hearing and present your case with the available evidence. If the opposition is upheld, you may have the option to appeal the decision before the IPAB or the High Court. Stay in touch with your attorney throughout the process to stay informed about the progress and any developments in your case. After considering both sides, the Trademark Registry or IPAB will make a decision on the opposition. They may either dismiss the opposition or uphold it, in which case your trademark application may be refused. Remember, folks, trademark opposition is a serious matter, but it's not the end of the world. Grounds for trademark opposition. In the world of trademarks, there are various reasons why your application might face opposition. Let's break it down into two main categories: absolute grounds and relative grounds. Absolute grounds cover explicit violations of trademark rules, such as descriptiveness, if your brand falsely identifies with a location it doesn't belong to. Then, generousness. Your chosen brand name should not contain generic name. Similarity. If your trademark is a direct copy of an existing brand, it could be opposed. And bad faith and fraud. It is believed that you applied for trademark registration in bad faith. On the other hand, relative grounds come into play when someone opposes your brand name based on priority or similarity. First, priority usage basis. If someone else had used the brand name before you did. Second, harm to existing brands, if your trademark could harm an existing brand name. Third, similarity to registered names, if your brand name is similar to a registered business or domain name. And fourth, similarity to well known brands, even without a trademark registration if it resembles a well known brand name. During the trademark opposition process in India, you need to submit certain documents. For the applicant, trademark application form, supporting evidence for your case, details of your trademark attorney, and for the opponent, trademark registration certificate if they own a registered trademark, evidence to support their opposition, and details of their trademark attorney. Defenses available against trademark infringement. Now let's explore some available defenses. Fair use. If the accused can prove they had consent from the trademark owner or used the mark descriptively for identification, it can be a valid defense. Prior use. The rights of the prior user override a registered trademark. So if someone used the mark before registration, they have a defense. No confusion. If the two marks have differences in essential features, there might not be an infringement. Marks used in different market. Differential geographical locations or classes of goods and services can be used as a defense, though it might not always hold up. Non-use of the mark. Unused trademarks can be challenged, but the burden of proof lies within the defendant. Delay and acquiescence. If the trademark owner waits too long to take action against infringement, they might lose their rights. Parody. A trademark can be used for parody or criticism, but not purely for commercial purposes. Invalidity of registered mark. A defendant can argue that the registered mark itself is invalid, giving them a defense. These defenses are essential to understand for both trademark owners and those accused of infringement. Always remember to be careful when choosing a brand name and be attentive to any opposition. If the opposition is successful, you could lose more than just your brand name. So, stay informed and make informed decisions to protect your trademarks. There you have it, a comprehensive overview of the important elements involved in trademark opposition. We hope you found this information valuable. If you did, please give this video a thumbs up and don't forget to subscribe to our channel. Thanks for watching, and we will see you in the next video.